Okay. I teach a class back home in Lake Charles at McNeese State University. That's our local university. And I tell my students this when I start them off, that I ask them, it's a business law class, it's an intro to law class, it's a business law class, and I'll ask them, how many of you know for certain that you want to go to law school? And I get the same amount, I get maybe one or two hands. How many of you know for certain you don't want to go to law school? The vast majority of the hands in the room go up. They know they don't want to go to law school. And a few people in the middle are uncertain. If stats are any indication, that those numbers will be a complete reversal. By the time I'm done speaking, you will no longer want to go into solo practice. And you that are uncertain, see, there's 5 of you, 2 or 3 of you are going to know for sure you want to do this, and 2 or 3 of you are going to know for sure that you don't want to do this, which is the goal. You have to know what this is, the good, the bad, and the ugly, if you're actually going to go into business for yourself. And so the first thing you have to realize, I would say, about solo practice is that like anything in life worth having, it's difficult. There's a reason why only 6 of you are here, because it is a difficult thing to do. I mean, today, right, OCI, Taylor Porter's here. What do most of your colleagues want? Most of your friends, what do most of my friends want? They want the big job with the big firm. I can get into this, I can rail about it forever, but it might be kind of a waste of time as to why I think that's not the best career path. But if you look at the numbers, there's no doubt that the fastest path to financial independence, the fastest path to financial security, the fastest path to being your own boss is through solo practice. It is not going to be in the context of a Taylor Porter or any big firm is going to bring you in. That's just empirically not true. Your buddies that are starting out with Taylor Porter, whatever they're going to make, nice salary, 100, 105, 110, their earning chart, if I could graph it out, their earning chart would be, what I would say is, if you started here, it might be a gradual, slow increase across the board. Raises over the time, over 30 years, and a gradual increase. The cool thing about solo practice is your start, while your friends may start up here around 120, and your start may be down here, your earning curve looks much more like this. It's much more rapid, and the earning and the potential, the cap, there is no cap. The cap is you. That's what's really cool about solo practice. The only limitation to being successful in solo practice is yourself, which is the funnest part about it. So, if you're going to do it, if you want to go into solo practice, this is what I tell everybody that's asked me about it. If you're going to do it, what does it take? I always tell people it takes 3 things. A, D, C. I couldn't find a B. I had to use a D. A, D, C. It takes, first, ability. And I don't just mean legal ability, by the way, guys, because the vast majority of you pass the bar exam, you have the legal ability, you have the legal acumen to be lawyers. So I don't expect that you wouldn't know how to do the job. You have the legal capacity. What I'm talking about is a personal capacity, personality. And I'm talking about a business capacity, a business sense. There are plenty of lawyers who are very good lawyers, very smart, but they have no business sense. So you have to have the ability business-wise to do the jobs. Third, personal capacity. To all your friends who are getting the jobs at Taylor Porter and all the big firms, I have never, not once, had a client come in to see me and ask me to give them some fascinating dissertation about comparative negligence. They come in, they have a problem. They want you to solve it. So telling your professor something fascinating doesn't do anything good for private practice. The ability to personally relate to these guys, this is what's important. Desire. I would say most people have this. Most people have the desire to be successful. Most people have the desire to work for themselves. Most people have the desire to do well for themselves and not be limited by somebody else. The biggest holdup, far and away, the biggest reason why people don't do this, and the reason why I think a lot of people maybe don't even consider it, is this reason here. It takes the courage to jump. You have to jump into the deep end of the pool. And for you that dare to do it like I'm doing it, right out of law school, it takes a tremendous amount of courage. What if I screw up? What if I mess up a client's case? What if the phone doesn't ring tomorrow and new business doesn't come? What if, what if, what if? And so you can what if this thing to death, but it takes the courage to jump. I don't know of a single successful person, I don't know of any risk venturing person, truly successful, that hasn't dared to dream or taken a risk. If your risk tolerance is low, solo practice is not for you. So you can know off the bat that this is not the right place for you. I'll give you a prime example of ability, desire. Most people have it, but they lack the courage. I'll give you a prime example of this. This is rhetorical. I know everybody in this room drives, okay? But prime example, take a look at this. Read over this. about parachuting and skydiving. That's amazing. 1 in 100,000 jumps results in an accident. How many people have skydove? 1, 2, 3. So half of the 6. All right. So risk takers. How many would you be willing to skydive over here? Yeah? No, not at all. See? Low risk aversion. That's what I'm talking about. Low risk aversion. How many of you skydove part of Lyon, the summer broad thing? That's where I did mine. I did it in Switzerland. Where'd you do yours?
Back home in Texas.
Back home in Texas. All right. Fair enough. If you ask somebody, do you have the ability to skydive? Do you have the ability, barring some heart condition or some health condition, do you have the physical ability to fall out of a plane? Of course, I have the physical ability to fall out of a plane. I don't have to do anything. I just have to fall. Do I have the desire? I mean, if you look at it, who wouldn't want, if you told somebody, I got a way to get you where you want to go faster, and it's a direct shot, you don't have to go through security, you don't have to get your baggage, we'll just fly you from Los Angeles to New York, you get over to New York, and we'll push you out of the plane. And you'll go straight down to your house, there's no luggage, there's no traffic, no nothing. Would you have the desire to experience a faster, a statistically safer way to travel? I got a safe way for you to travel, I got a fast way for you to travel, I got a convenient way for you to travel. Would you take it? They'd say, of course, I have the desire. Why don't they do it then? If they have the ability to fall out of the plane, if they have the desire to get somewhere safer, faster, more efficient, why don't they do it? It's fear. It's just simply courage. They don't have the courage to jump out of the plane, to take the jump, quite literally to take the jump. So the only reason why people don't do this is courage, guys. That is the single reason why people don't do it. So, assuming you got the ability, you got the desire, you got the courage, I kind of want to give you guys a 64,000-foot view of this. I want you to see it from a grander scheme, to see the idea of solo practice from what I would say kind of more of an emotional standpoint than an intellectual standpoint. I'll get into the nuts and bolts. I mean, I'll tell you all about practice software and tips that you should do and all that kind of crap. We'll talk about all that. But first, you have to know if solo practice is what you want to do from a heart perspective. You have to know here that you want to do it. What I would tell people when they ask me about law school is they'd say, how's law school going? I'd say, most people have a really depressing version of how law school is going, but they would ask me and I would say, the difference between 3 hard years and 3 miserable years is whether you love it. There's no doubt that law school is hard, and we all know that law school is hard, but the only difference between it being miserable or hard is if you love it. So, same thing in private practice. It will be time consuming, it will be hard work, it is not easy, but if you love it, there's nothing greater than the feeling of being your own boss. So, what does it take then? Let's assume you have the ability, desire, and the courage. Let's get past the hard stuff. Let's get in the meat of it. If you want to be your own boss, what does it take? You have to be the following to be your own boss and run your own firm. A janitor. You got to be your own IT guy. I got a call today on the way here. My phones are down. Fantastic. Advertising professional, networking professional. You got to be a counselor, and I mean not just a counselor like a counselor of law. I mean an emotional counselor. When they come into you, they don't want to know about comparative negligence. They want to know about, my aunt got hit by a car, can you help? And they want a shoulder to cry on. A mediator, a carpenter, a painter, and a plumber. I had to do this to one of the offices that we renovated to make room for more people. A manager, of course, right? You're managing people. You're a human resources executive because you're managing not only yourself and your business and your finances, you're managing people, right? So then, of course, you're a human resources executive. You're the accountant, and you're projecting your numbers into the future as a financial analyst. So you're the accountant and the financial analyst. You're an architect and interior designer. You have to be willing to embarrass yourself, by the way, in all capacities, in all forms. You cannot be afraid of being embarrassed. And last but not least, you have to be a lawyer if you want to have solo practice. I put that specifically at the bottom, that you have to be a lawyer at the bottom. That's the least most important thing. So I'll take you through 3 myths about solo practice, and when I finish the myths about it, these are the most common myths about solo practice. When I finish the myths, then I'm going to get into some nuts and bolts for you guys so you can hopefully take something away practical about it, okay? First myth. It is the only kind of practice that requires me to jump into the deep end of the pool. This is the biggest piece of nonsense that you and all of your colleagues are talking about. All your friends talk about, well, I mean, the idea of me opening up solo practice, it sounds great, right? But if I go to work for another firm, they'll have an experienced senior partner that I can work under, right? They'll have an experienced junior partner that I can work under. They have a partnership track even. I can get in this track program. They have a mentor program. They have people that I can work under and study. If I go over to the DA's office or the PDO's office, they have programs to help me. If you know of a lawyer or if you've met a lawyer, please introduce me to this person, the person who knows of the nice, smooth, easy way to transition into law. It doesn't exist. I can tell you right now, when I went to work for the DA's office, because that's what I did, I started my solo practice right out of law school, opened up my own law firm, and also the DA in my parish had a unique opportunity for me where I could work at the DA's office and have a solo practice on the side. Very neat kind of opportunity, something you guys may want to consider. Helps you to kind of keep your light bills paid while you build your solo practice, if that's an option. After 2 years, it reached a point where I was burning the candle at both ends and I had to choose. So I chose, of course, what my dream was to begin with, which was solo practice. But while at the DA's office, I can tell you my first day I walked in, there was a stack of files this high on my desk, and they sat it all down and said, start reviewing these. There was no tutoring program. There was no talk about how to review for Fourth Amendment violations, if the cops did the right thing. And it was, by the way, your first trial's tomorrow. You are literally thrown into the deep end of the pool. In private practice with big firms, you will be thrown into the deep end of the pool. So don't think that if you're doing solo practice, it's the only profession where you get thrown into the deep end of the pool. It happens in every single form of practice. Don't buy the myth from any of your friends that, I think it would be nice to work for myself. And I get your point, James, and it makes a lot of sense, but you're going to be out there by yourself deep into the pool and you've got nobody to lean on. That's just not true. We'll get to that down the road when I talk about mentors. Myth number 2. I love this one. It can wait. Love this one. Great idea. Open up your own practice. But just give it a couple of years, right? You're young. Give it a couple of years. Work 2, 3, 5 years for a big firm or something like that. Get some experience, get your name out there, that kind of thing, kind of wade into the pool. So it feeds back into myth number 1. Wade into the pool, get in the shallow end first, at 4 feet, 5 feet, 6 feet, and get a little deeper, and then you can go ahead and jump. Because then at that point it's 6 feet to 10 feet. That's simply not true. What happens is, and what most of these big firms bank upon, is that if they can get you in for anywhere from 2 to 5 years, they know, statistically this is true, they know they won't lose you. Because what you get accustomed to is a lifestyle. You get accustomed to $100,000 a year. It's amazing how people find a way to spend money. People can live off of $20,000 a year. They find a way to live off of $100,000. At that point, married, you might have a kid, and then you try to jump out on your own. What's the argument? But we have a child with braces and college funds, and you're going to do this to us and our family, and blah, 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 blah. It'll never happen. It'll never happen. It is now or never, and I would argue the only time to do it is right out of law school, when you have no mortgage, when you have no kids, when you have no financial commitments, when you can spend nights on the couch by yourself in your law office eating tuna fish sandwiches, and nobody cares because you don't care. But when you have somebody depending on you after 5 years, or you're leaving $100,000, you're quite used to it, and your rent's pretty expensive, and then you take the jump, you make it much more difficult on yourself, guys. There's ways that you can network. There's ways you can gain experience, and I'll talk about this. DA's office was an interesting way that I did it. The myth of it can wait. You're delaying your dreams, and I think in a high chance you are actually mortgaging your chance at your dream because you are waiting too long. Myth number 3. Yeah, this is my favorite. But the other job has a guaranteed check. There's no guarantee the phone's going to ring. There's no guarantee the phone's going to ring tomorrow. What do I do? Oh my God, this other firm, it's a guaranteed check every 2 weeks. I have a friend of mine. I'll give you 2 examples. First is a friend of mine. She works in government. Loves her job, loves the people, and she is guaranteed her check through the government. Very secure, right? Arguably a guarantee, very secure. There is a promotion available to her in her agency right now. They want her to have the promotion. She is the most qualified person for it. The spot is open, but guess what? State's on the verge of bankruptcy. Hiring freezes across the board. She's not getting a job. Give me a break that the state is a guaranteed fund. It's not. There are no guarantees in life. The only guarantee is death and taxes, and even taxes is not that much of a guarantee. I know people that have died still owing the IRS taxes. I mean, you're maybe guaranteed to owe it, but not to pay it. I mean, death is the only guarantee. The other myth, private practice. What guarantee is there? I'm just curious, what guarantee is there if you work for a private defense firm, say Taylor Porter? What guarantee is there that Exxon doesn't call Skip Phillips and says, listen, we're going fully in-house, and we're going to have to close down, your Exxon division. And Skip sends an email, and your job is gone that day. There's no guarantees, guys. So there is risk in private practice. There is the fear of, will the phone ring? Sure, I understand that. But don't buy into the myth or the fear that your friends are propagating to you, which is that These other jobs are guarantees. There are no guarantees in terms of your check. All right, nuts and bolts of it. Getting the nuts and bolts of it. Starting the practice. The first thing, absolutely far and away the most important, is location. I think that there is some room for this in what people call the high-tech area. Can I truly run my law firm out of a coffee shop? It is more high-tech. There is the ability to run a law practice off of a laptop. I do think that is moving in that direction. But it depends on your market. If it's New Orleans, it's more palatable. If it's Lake Charles, where I'm at, they're much more old school and they want to see a physical location. And so for me, my law firm, just personally for me, started on my laptop. It then moved. I started getting enough cases and files that I had to get an actual office. So I got a room in my house, 3-bedroom house. I have 1 bedroom and I had 2 roommates. One roommate luckily left, and I took his room and made it an office. And so I started to kind of jam pack over some time, files and things like that. It got so big that I had to kick out my second roommate and take over that room for my conference room where I could meet with people if I had to. Actually met with some clients in my house, believe it or not, when I started out. When I brought in my first associate, Scott, our first 2 weeks were at my kitchen dining room table. That's where we started. And at that point, we knew we had to move from somewhere. So we rented an office space behind a friend of mine who has a solo practice, Sean Corcoran. He was here at LSU, and he has a solo practice. We rented one office back there thinking, look, we'll just get one office, we'll split the space, and we'll use the space. We expanded into 2 offices. When I talked about the carpenter, plumber, painter thing, we had to expand to a 3rd office because today we've gone from 1 people to I'm now at 5 people. And it started being in my own house, picking up the phone, trying to sound somewhat professional and say, this is James, or law office, and just let them say something and try to appear professional. And just yesterday I was walking down the hall and now I have a dedicated receptionist, and I heard her say, a very nice voice, very polite voice, good morning, thank you for calling Sudduth Associates, how can I help you? And you go from law office in your kitchen room table to somebody saying that's kind of the fun of private practice. It's seeing something grow. It's hearing somebody that you don't know that you've just hired saying your name. Thank you for calling Sudduth Associates, how can I help you? And one of my first clients, one of those people that met me at my house, had to call and go through that automated system to get to me. And by the time she got to me, she's like, well, look at you, big shot. It's fun. It's a change. And you're building something. That's the fun you have to be willing to take on if you're going to be in private practice. And now, we just got the renderings from the architect. Now we'll be constructing this to move next to the courthouse. This will be our new facility, which will have spaces that we can rent upstairs and that kind of thing. We'll be moving to about a stone's throw from the courthouse. So from your kitchen dining room table to right by the courthouse. It's a fun process, but it's incredibly hard and very time consuming. But it is something you can do, trust me. And most people don't even dare to think about it, don't even dare to dream about it. Mentors, I talked about this, huge. I found my mentors through networking, through events that the Bar Association would put on, the local Bar Association, and through my time at the DA's office, and found a solo practitioner. His name was Alvin Hunt, who was kind of winding his practice down and wanted to kind of pass off some cases to me, and he would pass some simpler cases at first just so that I could learn and things like that. Again, goes back to courage, having the courage to reach out to a mentor and take that step and just say, I'd like to follow you for a day. I'd like to see what you do. Crazy, right? Just totally inappropriate. What are you doing walking up to me and just asking that question? You'd be amazed how willing these guys are and how excited they are when you ask them that question. Terrifying at first. I'm not going to lie. It's terrifying to walk up and ask that question. But it is important. It is important to network. It is important to make those contacts. And those guys, you talk about forming a network or a team of mentors, these mentors will help you. Just like your senior partner will help you, Taylor Porter. These people will help you, but they won't take 90% of your fee. These people are going to help you and let you collect your fee. And they're happy to do it because they're on the downhill slide and they're leaving their practice and they want to see a young guy do well. It'll be the same thing to you. Planning and setup. I jumped to the bottom on this one. I'm not going to lie. This is a total pain in the you-know-what. I mean, the setup is just the biggest, it's awful. But, like I said, you can't see this. Okay, I got to change the color. This says, also the coolest as each new thing comes into being, you feel more and more official. Like I said, saying, this is James, to somebody answering my phones for me. As each new thing comes online, you feel more and more official. But I'll take you through a laundry list if you want to see it nuts and bolts wise. You don't even think about this stuff. Notepad, stationery, right? My logo, you saw that in the beginning, the logo, stationery. Your online practice software, you're going to use Clio, you're going to use Cosmolex, the pros and cons of each one of those. It is important, I think, to be cloud-based. Practices are going very, very high-tech, and to be paperless, to be cutting edge, to be young, you get an advantage over your peers, your older firms who are still in the Stone Age, so that is important. Business, you need to think about it. Business cards, business cards. You don't even think about this stuff, but having that. Of course, your logo. Voice over Internet Protocol system. I cannot tell you how complicated it was to get Suddenlink to give up my phone line so I could send it to a cloud-based server, a voice over IP protocol system, so that now I pay for the cost of one line, one internal line, as opposed to here at LSU, they're paying Suddenlink for the 500 lines they're bringing into this building. I pay for one line, and I split it electronically in the cloud 500 ways. So I pay for one line, and my extensions are a plethora, and I run my own phone system internally. Voice over Internet Protocol, very high-tech, very cutting edge, but a complete pain because it's so cutting edge, it's so new. This is something growing too with younger practices, what's called a unified communication system. Everybody's singing off the same song sheet. Your phones, your copiers, your scanners, your fax machines, everything that every machine is doing, everybody can see because it's all linked through a server. Letterhead, of course, an email account. This is more important than you think, and it's not that expensive. It is, I would say it is, it goes to appearance. Appearance is so incredibly important. If you don't, what's the phrase, fake it till you make it? If you're not there yet, if you haven't made it, fake it. It is so incredibly important. You get a letter from another law firm and they send out their letterhead with all their lawyers that they have on staff and all their counsel. It's an intimidation factor. It's like a bully in a schoolyard playground. You filed a suit, which is the first declaration of war, and they're going to file back. They're declaring war back, and they're going to play intimidation. Persian rugs, artwork, letterhead. That's what they're trying to do. You have to play back. Letterhead. Letterhead is just so important. You wouldn't even think about it. Your email. Let me tell you how tacky it is for them to email me, and I respond back at james@gmail.com. You don't even think about that. But the guys back here that work at LSU, how they don't even think about this, that they just walk in and it's eGaruli at LSU Law or LSU.law.edu or whatever it is. That's just given because LSU has created that account. You got to go out in private practice and create that yourself. But now, my email is james@SAA, Sudduth & Associates, SAA.legal. It was also a complete pain in the butt. I have a cutting edge domain name. I don't have .com or .gov or .net. I have .legal. It's kind of fun, but it sets you apart. Another way to set yourself apart. You have to pay for it. You have to pay through Gmail to have that server classified. Of course, it's $10 per user or something like that. But to have that appearance that you're emailing from SuddethLawFirm.com instead of gmail.com, huge to your clients too. Of course, a website, absolutely, that's a given. For your staff and for yourself, corporate credit cards, business expenses, tax-deductible expenses. And this is the other thing too, if you go into any kind of big firm, what are they going to have for you? They're already going to have a subscription for you to Westlaw and Lexis. They're already going to have a subscription to all these clerk of courts and all these parishes and all their websites so you can log in and see all their documents. You got to set all that crap up yourself. You have to go in there and buy all these subscriptions yourself. Pain, but once you have it, very, very good. General overhead, of course, lighting, that kind of thing, chairs, desk, equipment, computers. My phones were broken today, but I think that's getting fixed. The other day, my monitor broke on me. And before, working in the DA's office, you just call a guy in IT, and it was just his job. You'd call your version of Isaac, and my monitor's broken, fix it. You don't even think about the fact that you got to pay for that monitor. You have to pay for that warranty. You have to pay for those costs. You have no idea. And then, of course, when you lose your monitor, you're down and you're not productive. Unbelievable what you don't think about once you're in business for yourself. File folders. What's some of those file folders? You walk into a supply closet and they've got file folders there for you. Now, again, you're having to take on, this is what I would call the burden section. You're having to take on these burdens that any other business is going to take on for you. You walk in with Taylor Porter, they will have this done. And they will have a desk for you with a phone sitting there and a computer sitting there. All you have to do is sit down and get to work. But what they get in response to that is they say, I'll pay you 105, I'll pay you 120, but you're going to generate 300 for me. You're going to generate 500 for me. And that's when I said that I just will not do that. I will not be, used. If my work is worth 500, I want to be paid 500, and I'll take the overhead on. Why don't we do that? That's what I did. I took the overhead on. These are the burdens you take on. This is the overhead you take on. But again, you take on all the benefit, all the profit. One of the things that Aaron mentioned she wanted me to talk about is client relations. This is huge. One of the things I'll tell you, the simplest thing in the world to do, just call them back. It's unbelievable how many bar complaints, it's unbelievable how many people have thanked me profusely because I call them back, and I'll call them back just to tell them I don't have an update for you. And they're just thankful that I've called them back. As lawyers, it's really easy for us. It's really easy to get focused on the law, and you're thinking to yourself, I got 50 clients. I've already worked his case. I've already done this for his case. He needs to chill out. I've done this. I'm moving on to this client. To simply call them back and say it's been done is huge. Call them back when they call you. You'll avoid yourself a lot of headache. I want to talk about this more when I get to fees, but I'll mention it here about being honest. When you quote a fee or you do anything for a client, even if it's bad news, you're telling them something they don't want to hear, if you give them bad news, I'd much rather say quote a fee that's too high for a client and they say no because they can't afford it. And they walk out and they say, I really like James, nice guy, just couldn't afford his fee. I can deal with that. I can deal with that kind of negative publicity, if you even want to call that negative. I just couldn't afford him. Versus taking on a client that I know can't pay me. I get frustrated. I started working his case. He can't pay. We get into a big dispute, and I've got to fire him. Now what's he going to say on the street? That piece of crap. So I can't deal with that negative repercussion. Be honest up front that I can't help you. I can't take your case. Save yourself a lot of pain by being honest up front. And of course, any kind of appreciation follow-up. Alumni relations here at LSU is great about that. Sending you football tickets if you donate, or calling you to thank you, or sending you a card to thank you. Any kind of follow-up to any of your clients, because they are consumers, they are customers, is huge. Not all this is common sense, but it's worth talking about. Fees. Yeah, what do you get to charge? I heard this when I started, so I'll tell you this. When I was starting out, I probably would have quoted people $50 an hour, $25 an hour. What am I worth? I'm brand new. I don't know what I'm worth. You have to start quoting the fee that you want to be paid and not the fee that you think you're worth, because there will reach a point in time when you are so seasoned and you are so talented that you could be charging $700 to $1,000 an hour, and you're not going to get that. You'll get $350 or $500. So go ahead and charge the $350, because the hit you take in the beginning, you'll take at the end whenever you can't charge the $350. Charge what you want to be paid, and you will be surprised how many will pay. You cannot be afraid to let a potential client walk. The single biggest advice that I can give you about quoting fees would be this. If you quote a fee, somebody comes in for, say, criminal defense. I'm at the DA's office for 2 years. They come in now for criminal defense, and I say $5,000. If I allow a client to negotiate my fee down, I want you to think about this intuitively. If I allow a client to negotiate me out of my own fee, why do they need me? Their job is or what they're doing is they're hiring me to be their negotiator. If they can out-negotiate me, why do they need me? That's what I tell them in the room. You're trying to haggle me out of my own fee, and you're really good at it. Why don't you go talk to the DA and you get your charge dismissed? Because you're really good at negotiating. They're hiring me to be their negotiator. And I'm going to allow them to talk me out of my fee. Never negotiate over your fees. Stick with your fee, whatever you quote, because you're worth it. You believe you're worth it. Your skill set says you're worth it. State of Louisiana gave you a bar license to say you're worth it. Your fee says you're worth it. You quote the fee that you want to be paid and not what you think you're worth. And if they walk, they walk. I guarantee you, I would rather work phenomenally well one client's case who's paying me $5,000 as opposed to taking 5 clients, working them averagely, and they're paying me $1,000 a case. I'd much rather let 4 people walk in a row and take one at $5,000. Yeah, and of course, not negotiating over your fees. Practice tips for growing. One of the things that I took on, of course, recognize a niche in whatever market you're in. In Lake Charles, the market's kind of interesting in that we've got $96 billion in development and growth in a town of 70,000 people. So my advice to you is to open up a solar practice, but don't come to Lake Charles. It's terrible. We're having a blast. I'd hate for any of you to come. So, stay away. Go to Baton Rouge, go to New Orleans, please. It's awful. But recognize a niche, and what was happening in Lake Charles was you had a lot of older blood, a lot of old guys that were passing on, passing their practices down to family, retiring, fading out their practices, and no new young blood moving in. And that created a vacuum, phenomenal for starting a business. Recognize the niche in your marketplace. Another area that I saw, employment discrimination. How many of you have taken labor or employment law with Corbett? You have? Have you taken it or are you taking it now?
I took employment last semester.
Okay. Would you say the case law is on behalf of the plaintiff or the defendant?
What do you mean? Like, is it?
Is it easier for a plaintiff to prevail in employment law than a defendant?
No, it's easier for defendant.
Absolutely. It's miserable for a plaintiff. Incredibly hard for a plaintiff. How do you prove discrimination? It's all insidious. It's all hidden. It's subvert. So what I saw was nobody was practicing the area of employment law as a plaintiff. And I took a case, it was one of my first cases. It was for a family friend. I won't mention a name, but this is the other thing you can do in private practice that you can't do in other cases. You truly can help people. You truly can take cases when you feel it's the right thing to do. And I took this case for a family friend. She is a type 1 juvenile diabetic, which means that through no fault of her own, she's suffering from diabetes, and the type of diabetes she has, the degenerative form of diabetes, it will kill her. It's a matter of time. And it's shutting down one organ at a time. And what it was shutting down at the time was her eyesight. So she worked for the Texas Department of Health and Human Services, the very organization who administers benefits to these sort of people, was blind, or going blind. And they fired her. Now, they didn't fire her for disability, of course. Maybe back in the 50s, you could have said to somebody, "Oh, you're black? I didn't know that. Get out of here." Now, who would say that today, 2015? There's no way. Wouldn't happen. So it's hidden. It's overt, or it's subvert. Discrimination is incredibly hard to prove. There are ways you can do it. But if you can prove the discrimination, the damages are huge. And it's a very complex area of law. So I'm suing the Texas Department of Health and Human Services right out of law school, represented by the Attorney General of Texas, and going off of trying to prove a case through circumstantial evidence because they say they fired her for workplace violence and not for her disability. And there's just tons of evidence to the contrary. Needless to say, I'm 2.5 years out of practice, and I'm lead counsel in a case going to the Fifth Circuit Court of Appeals in New Orleans. It's unbelievable when you're in private practice.